Good afternoon. I think, Mr. Shea, we are able to resume. Thank you very much.
I'm grateful, my lord. My lords, may I take you please to Article 14.3, the fourth sentence of that article in the FTA at bundle page 379. That sentence provides that under no circumstances shall the arbitrators, brackets S, apply any rule, brackets S, that contradict, brackets S, the strict wording of the agreement. Now, those strict provisions, we say, include both English law and unidroit, and the extent to which they may differ from, or indeed contradict each other. And in opting for the application of both English law and unidroit, it's noteworthy that the parties did not include any hierarchy clause within the FTA which might specify the order of precedence of any contract provisions. And so the express choice of the parties, even if it be peculiar, was therefore to opt for a dichotomy of laws, we say, an amalgamation of laws to apply to the contract. Now, their intention, as written in the clear language of their contract, was not to give either unidroit or indeed English law precedence over the other. There's no language of that sort, and we say that contrary to the respondent's written case at paragraph 47(3) and paragraph 84, that's at bundle pages 222 and 234, there's no language in the FTA which suggests that the unidroit principles must serve only to fill, to quote the respondent, any gaps left by English law. We say it follows that, as with the choice of English law pursuant to Article 15, the choice of unidroit to govern the substance of the FTA, as per Article 14.3, also forms part of the strict wording of the agreement. And so, if there were a departure from English law or unidroit, but a departure, for example, from unidroit by failing to give effect to those principles, then that could, of course, amount to a breach of the strict wording of the agreement. Now, I note here that the Court of Appeal, in its judgment at paragraph 76, and that's bundle page 286, accepted that the strict wording of the FTA can be overridden, and I quote, to the extent permitted by English law as the governing law of the FTA. Now, we say that insofar as unidroit was also expressly chosen by the parties to govern the substance of the FTA, the unidroit provisions may also be relied upon to override the strict wording of the FTA, including, for example, the NOM clauses which are relevant to issue 2. Now, going to paragraph 47(3) of the respondent's written case, which is bundle page 222, their assertion is as follows. They talk of the third sentence, but I think the respondent means the fourth sentence. They say the third sentence narrows down the second sentence by directing the arbitrators not to apply any rules that contradict the strict wording of the agreement, including therefore not to contradict English law. In other words, principles of law generally recognized in international transactions can be used to fill gaps in the provisions of the FTA and English law, but not to contradict either. We say that contention concerning filling gaps and complementing English law but not contradicting it can't be right. Unlike the French and English parties in the Channel Group case, which I mentioned earlier, the parties to the FTA did not specify or restrict the principles to be applied to the common principles of English law and unidroit. And so we say that at paragraph 84 of the respondent's written case, and that's page 234 in the bundle, they're wrong to rely upon the preamble of the unidroit principles in respect of this gap-filling argument, because the application of unidroit is not only used to fill gaps in and supplement the terms of the FTA, including English law. We say that it forms part of the system of laws or sets of principles which apply to or govern the substance of the FTA in the same way as English law. There's no wording, for example, to say that unidroit is subjected to and conditioned upon the primary application of English law under the contract. And similarly, the preamble to unidroit does not, in fact, assist the respondent's case, we say, given the word may, which indicates that the use of unidroit may be used to interpret and supplement domestic law. is only elective and could have a different purpose. And we would like to point to another passage in the preamble of UNIDROIT, which is at bundle page 1389, which provides, and I quote, that the UNIDROIT principles shall be applied when the parties have agreed that their contract be governed by them. We say that's precisely the case under this FTA, where the arbitrators are directed under Article 14.3 to apply UNIDROIT, without, however, limiting that application to fill gaps or simply supplement English law. So we say that properly construed in order to give business efficacy to the express language chosen by the parties, the requirement that under no circumstances shall the arbitrators apply any rules that contradict the strict word in the agreement does not have the channel group applicable law clause effect of subtracting any principles of either English law or UNIDROIT from application, nor does it have the effect of preventing their application. Why is that, my lords? Because UNIDROIT applies, and I quote the word, also, which is at FTA Article 14.3 second sentence. So we say both English law and UNIDROIT apply because they're both provisions of the agreement, to quote Article 14.3 first sentence. And therefore, the application of each of English law and UNIDROIT each fall within the strict wording of the agreement for the purposes of Article 14.3 fourth sentence. These provisions aren't given greater force than the other. So the applicable law provisions concerning English law and also UNIDROIT, we say, are equivocal. And I'm about to come on to Article 15, my lords, because we submit that the use of the word govern in relation to the law or laws applicable to a contract has no more force than the use of the word apply. Article 15 is a simple and conventionally worded governing law clause, which uses boilerplate language. It says this agreement shall be governed by and construed in accordance with the laws of England. But as I've already said this morning, the provisions of the FTA concerning applicable law are circular and they're non-hierarchical. So the contract states nowhere that the application of English law shall enjoy any hierarchical superiority over the application of the UNIDROIT rules. And as indicated in respect of the preamble to UNIDROIT bundle page 1389, those principles, inverted commas, shall be applied when the parties have agreed that their contract be governed by them. The 14.3 second sentence instruction shall apply a particular system of law or set of legal principles is no less strong, we say, than the words govern, or the word rather, govern. In other words, the law or set of legal principles which applies to a contract is the law which governs that contract and or according to which that contract falls to be construed. Where parties, my lords, use general language such as shall apply or shall be governed by, then this would normally be interpreted as meaning shall apply to or govern both the substance of a contract and interpretation of it. And I pause to ask the rhetorical question, my lords, would the effect of this language at Article 15 have been any different if the wording of this clause had read as follows? The laws of England shall apply to this agreement, and it shall be construed in accordance with them. The appellant submits that the effective meaning of the words govern or apply in this instance is the same, and so they have equal value in the context of the FDA, as do, we say, English law and UNIDROIT. The contract instruction was that the UNIDROIT principles also apply, not that they apply as the lesser cousin of English law. And so if one applies a law to a contract, one applies it to both the substance of that contract and its interpretation. One more point, my lords. It's also, we say, inherently unlikely that international parties who agreed this contract, whose native and mother tongue was not English, would have thought that there was any difference in meaning between the English language phrases applicable law and governing law. And I hope to make good that point by looking now at the language of Article 14.7 of the FTA. That's at page 379, the same page. And your lordships will recall this morning that I read it out. The award of the arbitrators shall be final and binding upon the parties and shall be automatically enforced without any revision of the merits of the case by any court of competent jurisdiction. Now, if one reads that language and compares it with Article 14.3, then one can see that the parties thought that they were providing for a final method of dispute resolution by selecting ICC arbitration with a parish seat. We say it's reasonably to be inferred that the instructions given to the arbitrators by the 4 sentences which one finds at Article 14.3 were written with this in mind, because, in other words, the parties' slight misunderstanding and their hope that any arbitration award might be automatically enforced, as they said, without any possibility of review by the court of the seat, or indeed by a New York Convention enforcing court, such as this court in this instance. As shown by the language of Article 14.7, we say, that helps us to understand why the instructions were given to, in inverted commas, the arbitrators in the 4 sentences of Article 14.3. So we submit that when looked at in the context, which is, as we know, important according to English rules of contractual construction and per would of capita, when looked in the context of Article 14.7, we say that the instructions which were given in the 4 sentences of Article 14.3 were given to those who might be called upon to resolve any disputes under the FTA. And FTA Article 14.3 should not be read restrictively as a provision which is an instruction to arbitrators only. We say that that's the business common sense reading of the instruction given in the 4 sentences Article 14.3. And this must have been the party's intention. Why? Because business common sense and the compromise in express wording that they managed to reach in order to agree the FTA included both English law and, as the parties wrote, the word also the unidroit principles. So that cannot have been a choice which they intended to make, we say, to apply one set of rules before one forum, for example, the arbitrators, and another set of rules before a further forum, be that the Court of the Seat, the Paris Court of Appeal, or any convention enforcing court, as here. And so we say that the parties must have indicated application of the unidroit principles by the arbitrators, believing, albeit mistakenly, that that was a final forum and that there might be automatic enforcement after that. And that's demonstrated, we say, by the express language of Article 14.7. There's a further point in respect of Article 14.5, which very simply on the same page says the arbitration shall be conducted in the English language in Paris, France. And the parties, of course, presumed to know and understand that they're therefore choosing the French courts as a supervisory jurisdiction. So implicitly, the law of the seat is specified in the FTA. It's French law because the French courts will supervise. And the French courts apply French law, which itself decides to apply substantive rules of international law to determine the law applicable to an arbitration agreement. And of course, that is demonstrated by the Paris Court of Appeal decision in the annulment application brought by the respondent in this case. And I will read from it briefly in translation. It's at page 565, my lords, of the bundle. French law provides that, pursuant to a substantive rule of international arbitration law, the arbitration clause is legally independent from the underlying contract in which it is included, either directly or by reference and its existence and validity are interpreted subject to the mandatory rules of French law and international public policy according to the common will of the parties without the need to refer to any national law. Now, the English law concept of separability is, of course, narrower than that of French law and treats the arbitration, French law treating the arbitration agreement as legally independent or autonomous from the host contract within which it may be found. This difference and the English approach, which favours a narrower concept of separability, is demonstrated by the fact that under the 1996 Act, per section 30, and that's at bundle page 31311, section 30 provides specifically that parties may agree that an arbitral tribunal cannot rule on its own jurisdiction.
So could you give me the bundle number again, please?
Yes, my lord. It's page 1311.
Thank you.
And so the point there, my lord, is that under section 30 of the 1996 Act, English law permits parties to agree that it won't be the arbitrators, if they so wish, that it will not be the arbitrators who determine competence, their own jurisdiction. And so we say, nevertheless, despite that slight narrowness of English law, the English law concept of separability compared with French law, we say it's not quite as narrow as the Respondent suggests at paragraph 31 of its written case, which is at page 216 of the bundle. My lords, the majority of this court has recognised that the concept of separability is still relevant to the conflict of laws analysis, and that was at paragraph 41 of my lords Hamblin and Leggett's judgment in Enker, which is at page 1734 in the bundle. Their finding was that separability provides the basis for weighing up the possibility that an arbitration agreement may be governed by a different system of law from the contract of which it forms part, which is also, of course, known as the theory of dépassage in conflicts of laws. In short, we say that separability is one of the reasons why an arbitration clause may be more readily, I quote here from paragraph 40 of the Enker decision. Separability is one of the reasons why an arbitration clause may more readily than the other clauses be governed by a different law. In addition, we say to the different nature of the clause when compared to the rest of the substantive terms of the contract. We submit that in this case, and to paraphrase my lords Hamlin and Leggett at paragraph 39 of Enker, which is bundle page 1733G, that there are several factors in the language of the FDA and FOAs which displace the assumption that the parties intended the FDA to be governed by a single system of law. We say also that a further element of interest in that respect is that by virtue of the language at FDA Article 14.3 second sentence, the parties specifically mandated the arbitrators, but as I've said, we say that means those resolving disputes, to apply the unidroit principles, which are transnational principles. And those espouse an approach concerning the common intention of the parties, pursuant to principle 4.1 of unidroit, which is at bundle page 1423, which is substantially the same as the French law principles correctly stated by this court in Dalla at paragraphs 14 and 114, and that's bundle pages 1577 and 1612. And of course, those principles were recently and authoritatively stated and applied by the Paris Court of Appeal in its 23rd June 2020 decision in this very case. And that's at page 565 of your bundles. The appellant, so wishes to note the respondent's allusion in its written case, and this is at paragraphs 15, 2 and 3, bundle page 210, and also at paragraph 44.2, page 220 of the bundle, to alleged differences between the approach of French law or between French law and the New York Convention. Now, we say that argument does not assist the respondent because it does not excuse or justify any failure by any enforcing court under the Convention to comply with the provisions of the New York Convention and the clear treaty obligations to abide by the same. Now, in our written case, I believe at paragraph 106 and page 179, we referred to Article 3 of the Convention. And my lords, that's at page 1295 of the bundle. And that Article 3 of the New York Convention provides that each contracting state shall recognise arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon, under the conditions laid down in the following articles. Now, of course, the following articles are the remainder of the operative articles of the treaty. We say that this imposes upon enforcing courts of contracting states a reciprocal duty, but not of a personal nature, of a treaty nature. I'll come back to that. To apply the convention in applications for recognition and enforcement and give proper effect to the clear terms of the convention code. And we'd said that in our written case at paragraph 106 at page 179. Now, what we say is that reciprocal duty is of a general treaty nature in terms of its reciprocity. It expects contracting states to reciprocate by following the treaty obligations set out in the convention, as opposed to any concept of personal reciprocity or an obligation in that respect, as between, for example, any two contracting states where there might be parallel proceedings brought before the court of a seat and also an enforcing court, one or more enforcing courts even. So we say that it's not conditioned upon the interpretation and application of the convention by specific contracting states, but applies unconditionally and undistinguishably to all contracting states in respect of their obligation to follow both the letter and the spirit of the convention.
Could you explain that last submission? I'm not sure if I followed it.
My lord, yes. It is said by the respondent that there may not be levels of reciprocity between French law and English law in terms of their particular behaviours when approaching convention cases, for example, as an enforcing court. Now, what we say is that the reciprocity obligation under this treaty at Article 3 is one of a general treaty nature, namely to follow the letter and spirit of the treaty, to respect a contracting state's obligations under the treaty. It's a matter or a duty to which my Lord Sales made reference, I believe, at paragraph 291 in the Enker decision, when he was discussing, and again, this is something I will come to a little later in my submissions, when he was discussing the default rule and its inflexibility under the convention test. So we say it's a general duty of reciprocation under the treaty to which all the contracting states have signed up, as opposed to, my lord, any obligation of personal reciprocity which one contracting state might have towards another, where, for example, my lord, there might be enforcement proceedings before the courts of one convention contracting state, and there might be annulment application before the court of the seat in another contracting state. And of course, that is the paradigm that we have here in reality in this case.
Okay.
My lords, I'm going to pass over a couple of points. Earlier on this morning, my lords, I took you to the law in respect of contract interpretation and the dicta in Sul America and also in Enker in respect to the fact that when English law is applying its rules as a forum, it will look to interpret the contract pursuant to pursuant to ordinary rules of contractual interpretation, which was in the dictum of Lord Diplock from the Compagnie Tunisienne case and cited by my Lords Hamlin and Leggett in Enker. I won't take your lordships back to the detail of my Lord Hodge's judgment in Wood and Capital now. I've already cited important parts of it.
I think you can take it, Mr. Shea, that
yes.
the court is familiar with the basic principles.
My Lord, yes. My Lord, yes, of course. But I do wish to just mention to the court the passage in Lewison, which is in the authorities bundle at pages 2667 and following, and which I say provides further colour in respect of construing a contract as a whole. And there are a number of paragraphs to draw your lordship's attention to. At page 2667, in order to arrive at the true interpretation of a document, a clause must not be considered in isolation, but must be considered in the context of the whole of the document. That's obviously a simple and well-known principle. Over the page at 2668, Lewison quotes Mr. Justice Andrew Smith in Phoenix Life Assurance and says each provision should inform the proper interpretation of the other, and the party's intention is ascertained by seeking from the start a harmonious interpretation of the contract as a whole, rather than managing to reconcile discordant interpretations of different provisions. Now, we say that our reading of the language of the FDA accords with that principle. In the EE case, which is next quoted, it was said, agreements should be read as a whole and construed so far as possible to avoid inconsistencies between different parts, on the assumption that the parties are intended to express their intentions in a coherent and consistent way. One expects provisions to complement each other. Only in the case of a clear and irreconcilable discrepancy would it be necessary to resort to the contractual order of precedence to resolve it. Now, my lords, as I've already explained here, there is no contractual order of precedence which is described in the language, the express language of the FDA used by these non-English and international parties. 7.11 simply says that so too an individual clause takes its meaning from the context of the document in which it is found, and that of course is consistent with the provision Article 1 of the FDA. 7.12, thus it is of the utmost importance to interpret particular clauses in the landscape of the instrument as a whole. Now, in that respect, turning over the page to page 2669 of Lewison, I draw attention at 7.13 to the citation by Mr. Lewison of this court in the case of Re Sigma Finance Corp, and in particular to the words of Lord Mance, where he said, of much greater importance, in my view, this is towards the bottom of the paragraph, in the ascertainment of the meaning that the deed would convey to a reasonable person with the relevant background knowledge, is an understanding of its overall scheme and a reading of its individual sentences.
Lord Leggett has a question for you.
I beg your pardon, my lord, I didn't see the raised hand.
Mr. Chair, I'm just trying to understand where we've got to so far. So far as I understand it, the long and short of your submission so far are that the validity of the arbitration agreement, which includes for this purpose the question of who's a party to it, is to be decided not purely under English law, but under English law plus unidroit. Is that where we've got to?
My lord, I'm having a difficulty with my sound. Can you bear with me for 1 moment, because my speaker is.
Shall I try again?
Yes, my lord, please.
Am I correct to understand that where you've got to so far in your submissions is to submit to us that when we in determining the validity of the arbitration agreement, which includes for this purpose the question of who is a party to it, the law which the court should apply is not purely English law, but it's English law plus unidroit principles. That's what I understand you to have submitted. And that's all so far that I understand you to have submitted. But if all this amounts to any more than that, please say so.
My lord, that is what we have submitted, that both English law and unidroit apply, and English law requires that an arbitration agreement be governed by a national law, as opposed to a national law and a set of other and independent legal principles. And so we say that it can't be the case that English law was the choice of the parties to apply to the arbitration agreement, because there is no order of precedence within the language, because the governing law clause is an applicable law clause. There is no less force in the words which are given to those who or the instruction given to those who are supposed to resolve disputes at Article 14.3 second sentence to also apply the
I see. So
unidroit
is this your argument then, that because the parties wanted English law plus something else, and they can't have English law plus something else, then they can't have English law at all? So there's no governing law as the arbitration agreement. Is that it?
My lord, it's not. That's not my argument. No.
Oh, well, sorry, then I haven't yet understood
my argument is
where
that,
it all takes you so far when you've said that English law plus unidroit applies.
well, my lord, if English law and unidroit both apply, then English law cannot be the law applicable to the arbitration agreement on its own, and English law says that it cannot have a non-national system of law, i.e. a combination or amalgamation of laws, applying to the arbitration agreement. And so what we say is that in that case, there would be no effective choice of law, no express effective choice of law in respect of the arbitration agreement. And then one comes to the question of implied choice of law. We say there's no sharp distinction, as was said by you, my lord, and Lord Hamlin, and indeed Lord Sales in the judgment in Enker. There's no sharp distinction between the question of express choice and implied choice. And then one comes to consider the language of the convention and what the parties subjected their agreement, the law to which, I beg your pardon, the parties subjected their agreement, or failing any indication thereof. And the question of what the indication must be, is there an implied choice here? Our argument, our submission, is that there was no express or implied choice of law applicable to the arbitration agreement as a primary submission, and secondarily, that there was certainly no choice of English law as the applicable law to the arbitration agreement. And if there was an implied choice of French law, then an implied choice of law at all, then that must have been an implied choice of French law, because that follows the default rule in the convention. But French law is also the law of the seat. And according to the factors, which I shall come on to a little later in my submissions, at which the common law test applies at paragraphs 170, subparagraph 1 to 9 in Enker, we say that we would fall within subparagraphs 6 to 9 of the Enker guidance concerning an approach to divining whether there had been a choice of law, express or implied, and what that choice was. And there we are assisted also by the convention. If there was no choice, then the default rule is that the law of the country where the award was made applies. And of course, we know that our own arbitration law, the 1996 Act, by way of Section 53, has made certain to update itself in order to ensure that regardless of where an award is dispatched from or delivered to a party, the award is deemed, as far as English law is concerned, to have been made in England at the seat if it is an English seat arbitration.
So, sorry to interrupt you once more. I haven't understood, and perhaps you could try to once more to get through to me, how the bit of your argument where the parties having chosen English law and uni droit, English law at some point disappears as a choice, and they haven't chosen it after all, according to you. That I haven't followed through.
My lord, English law doesn't disappear as a choice of law applicable to the contract. It's applicable and has equal valency on our case with uni droit. So those resolving disputes, the arbitrators or others, are asked to apply both and to have to grapple with whatever difficulties that may present, because that's the express language choice made by these parties. So that's the first. I beg your pardon, my lord.
Including for the arbitration agreement, as we discussed earlier.
My lord, we don't accept it that it's including for the arbitration agreement. The arbitration agreement is one of the provisions in the contract, but Article 14.3, those 4 sentences, and perhaps it bears reading them consecutively.
No, it doesn't bear reading them again, but I've got them off by heart by now. But what does bear explaining is how the fact that the addition of uni droit in those, as you say, means that English law is not a law that the parties have chosen to determine the validity of the arbitration agreement, even if they also chose something else to be taken into account.
My lord, I've sought, I hope, to begin to explain our position on that, and it is something which I have further submissions on, which I am coming to immediately after this citation of the Re Sigma case.
Well, I think we all know that the contract must be construed as a whole. I would find it more helpful to know how you get past the point that English law seems to be the law expressly chosen to decide the validity of the arbitration agreement. And even if uni droit principles are also to be taken account in that process, I don't at the moment see where that gets you.
My lord, there's a difference between the applicable laws, we say, to the agreement as a whole, and whether those can apply to the arbitration agreement, because with English law and uni droit applying, English law provides that it cannot be a combination of laws or a non-national law which applies to the arbitration agreement. And if one takes into account the uni droit principles, then and applies those principles and decides that English law will allow non-national laws to be applied, then one would certainly arrive at the result where, if one were applying a combination of English law and uni droit to the arbitration agreement, that there might well be a decision which were very similar to the decision made by the Arbitral Tribunal and the Paris Court of Appeal in respect to the fact that KFG is bound by the arbitration agreement. That would be our submission if that combination of laws were being applied. But that combination of laws not being an effective choice means that the effective choice of the parties, whether by implied choice or by application of the default rule under the Article 5.1a test, is the law of the country where the award was made, namely France. That is.
Okay, thank you.
I wonder if I could just take you back. You're quoting from Lewison, and you make the point by reference to Phoenix Life and EE about the need to look for a harmonious interpretation of the contract. But your case, namely that there is no degree of precedent in English law and uni droit, places the arbitrators in the difficulty that they may have conflicting rules between English law and uni droit, for example, on the equivalent of estoppel, and B, it would give rise to the situations that Lord Legate's been discussing with you, namely that you have a provision in Article 15 providing that the governing law is the law of England, but you say, absent a precedent between it and uni droit, it cannot be the governing law of the arbitration. How is that submission, based on the absence of a hierarchy, consistent with what we're being told in Phoenix Life and EE?
My lord, it's consistent because there's specific provision under English law, and I cited Russell at paragraph 2119 earlier today, that English law does require that a national system of law govern the arbitration agreement. And so here the parties have expressly chosen to apply English law and unidroit also. Now, it is true, my lord, that from, I'm sure, the perspective of any judge and the perspective likely of any arbitrator, that it would not be an easy task necessarily to apply or give effect to the parties' expressed choices to multiply, amalgamate and add the laws which are applicable to their contract, which is what these parties chose to do. But although that potentially may be a difficult task, that is the task with which any arbitral tribunal in this case is faced, and equally the court of the seat and or any enforcing court. And it was a task which we say and we refer to and rely upon the award of the arbitrators, which was manfully undertaken by the tribunal and produced a majority award which was correct in its decision on the merits, but also correct in applying, as they did, the law of the seat. And of course, they were looking at things, they decided that French law, and they decided this unanimously, my lord. I've provided the reference earlier this morning. The entire tribunal of three, which included one common lawyer, an Irish senior counsel, decided unanimously that French law applied to the arbitration agreement. And
but
so,
what does that get to, Mr. Chair? Sorry, I just simply don't understand that. That they were looking at it from what law they must apply as the arbitrators. We're applying Section 103 of the 1996 Act. We're not in the position of the arbitrators. And that tells us to apply the law to which the parties have subjected their agreement, not the law of the seat.
well, my lord, depending upon what the law they've subjected their agreement to is.
Well, you can argue about that, but you can't rely on what the arbitrators did to get you anywhere, because they weren't applying the test that we're applying to choose the law.
Well, my lord, the arbitrators were applying what they understood to be the appropriate laws in order to determine whether the arbitration agreement was valid, exercising their competence jurisdiction in Paris. Whereas,
yes, but that's not what we're doing here, is it? We're applying Section 103 of the Act.
Well, my lord, you're applying Section 103 of the Act, but that's Article 51A of the Convention, and that test is clear that it requires, it has the language of subjection in it. It verbatim, Article 51A states that the law applicable to the arbitration agreement shall be the law to which the parties subjected their agreement, or failing any indication thereof, the law of the country where the award was made. Now, in respect of that test, we say that the default rule is precisely as my Lord Sales described it at paragraphs 289 to 291 in ENCA, namely an inflexible default rule, which gives effect to the policy purpose of the convention to seek to ensure the recognition and enforcement of arbitral awards, and which provides a simple and easily applicable test by which it's easy to judge whether contracting states are complying with their treaty obligations or not. But yes, my lord.
Well, is it then your submission that there's no indication in this agreement of any law to which the parties have subjected the arbitration agreement? Is that, I mean, does black mean white, or
My lord, we say there's
you put governed by English law, that's not an indication?
My lord, we say that there is no clear or unequivocal indication of law. First of all, though, my lord, and taking the first part of the language of the Article 5.1a test first, we say that the law to which the parties subjected their agreement clearly includes the active voice of the verb to subject. It is the language of subjection which the parties must expressly have undertaken and agreed or expressed in their language. So those words, we say, do not permit of an interpretation which includes both an express or implied choice. The implication part of the test, we say, is based upon the words or failing any indication thereof, where an enforcing court may inquire and consider whether there is any sufficient indication in order to constitute an implied choice of law to govern or apply to the arbitration agreement. Now, our position is that because of the equivocation within the contract between English law and UNIDROIT, that, as a matter of English law, can't be an effective choice of English law only to govern the arbitration agreement, which is what English law would require, because it requires a national system of law to govern the arbitration agreement. Secondly, if there is that equivocation, then one is in a position where there is no clear language of subjection to a law which gives effect in respect of being an effective choice of the arbitration agreement. If that is the case, then what other indications are there? Either one finds that because of that equivocation, there is no indication whatsoever, and therefore the default rule applies to the law of the country where the award was made. Or one considers that to give the guidance which you, my Lord, and Lord Hamlin gave in the majority judgment in Enker at paragraph 170, subparagraph 6 to 9, one finds that because there is an indicator that there was no clear express choice, therefore one considers other language in the contract, namely the choice of seats, which, as this court found in Enker, is an important consideration. And that is where, in the common law test as restated in Enker, the gap is bridged, or where the gap was sought to be bridged between the policy perspective of the English common law concerning trying to provide certainty, and I'm thinking of paragraph 53, of course, in the judgment in Enker, the search for certainty, consistency, avoiding complexities and uncertainties, avoiding artificiality, and seeking to ensure coherence. Now, of course, we're not in a position where whatever the infelicity of express choices of language the parties have made, where a court, an enforcing court, or indeed a court of the seat, should be rewriting or seeking to rewrite their contract for them. Their contract was their contract, as poorly or well expressed in terms of language and choices of applicable law or amalgamation of them as that might be. And so it is, that is, as I've accepted, potentially a difficult position for any judge or arbitrator to be in order to make sense of and create harmony between English law and UNIDROIT, but it does give effect to the express choices of the parties. And I recall there, and perhaps we should briefly look at it, my Lord, because it may help, Article 3.1 of the Rome Regulation, because in Enker, my Lords, the panel instructed itself and took into consideration the international perspective. At page 1969 of your bundles, you'll find the language of Article 3.1 of the Rome Convention. And there, under Article 3, entitled Freedom of Choice, 3.1 says a contract shall be governed by the law chosen by the parties. The choice shall be made expressly or clearly demonstrated by the terms of the contract or the circumstances of the case. And so what we say in respect of that language is this: international standards such as the Rome Regulation, or as here, the New York Convention, require that any indication has got to be clear, equivocal. And so we say that there is no, if one is to adopt or think of the convention here in the same manner as one would think of the Rome I regulation, there must be clear indication, at least, we say, for there to be any indication giving rise to an implied choice. Now, would that indication be clear, given what we've seen in respect of the perhaps unfortunate expressis verbis choices made by the parties in this contract? We say no, because they clearly chose, however unfortunately, to effectively apply English law to their contract, but using the word also the unidoir principles. And so that is the conundrum that one is faced with if one is an arbitrator dealing with this contract, or indeed judges of the Court of the Seat, or indeed this enforcing court. And I appreciate it. It's unfortunate in the sense that it is not something which, as I think I said earlier today, that a judicial eye would hope to see parties choosing. Just as the language in the Channel Group applicable law clause wouldn't be language that a judicial eye would hope to see, because but that was a more difficult clause with subtractive effect, whereas here it's a question of harmony, my lord.
Well, my difficulty with that is that your submission depends on the arbitrators being given an instruction which is unharmonious, namely that they are given English law and unidoir and told to get on with it. The Court of Appeal's interpretation of 14.3, which treats English law as the governing law and treats the second sentence of 14.3 as merely allowing the unidoir principles to fill in gaps, as it were, where English law may not have a particular rule, and then interprets the fourth sentence of 14.3 as saying that in no circumstances can the arbitrators apply rules contradicting the strict wording, prioritizes English law. That is obviously an interpretation you don't favor, but it would remove any disharmony.
But my lord, according to, if arguendo, the common law test guidance set out by my lords Hamden and Leggett in respect of the common law test to determine the law applicable to an arbitration agreement, because there is this aspect, this additional aspect. We're interpreting a contract, but we're actually interpreting also an arbitration agreement, and perhaps it might assist if I take your lordships to the relevant paragraphs of guidance in ENCA, which I believe are at 1760 in the bundle. Now I'm wrong, I'm afraid. They're at 1770 in the bundle, and those will help me, Lord Hodge, deal with your question. Or
thank you.
Because there one can see that while, as I've submitted earlier, the ordinary English rules of contract interpretation, if applying the common law test, do not go out of the window. They're still the means by which one considers the text, the context, how words and the language of a contract fit together. If one is applying the common law test under Part 1 of the Act because you have an English seat arbitration and you're trying to determine the applicable law, the guidance which this court has now given is encapsulated at paragraph 170, subparagraphs 1 to 9, in the case of ENCA. And so that guidance is obviously there and has been given in order to try and achieve consistency of approach in applying the common law test where you have an English seat arbitration. Now, the question, of course, to which I'll come later is whether the convention test is any different from the common law test. But considering this guidance and arguendo that it might apply in the same way because the English law rules of the forum are used to in respect or applied by an enforcing court, I beg your pardon, when looking at what the choice of law was, if any, by parties under Article 5.1a, and so Section 103.2b of the 96 Act. When one considers paragraphs 1 to 5, that provides the further guidance specific to arbitration agreements that there is to be a general rule or general presumption in favour of the main contract governing law. However, there may be additional factors which displace that presumption. Now, as part of the answer to your question, Lord Hodge, paragraph 170, subparagraph 5, which is on page 1770 at between G and H, we come to the sort of point of consideration or beginning to consider a seat and what the relevance of a seat of an arbitration might be. And so that provides that the choice of a different country as the seat of arbitration is not without more sufficient to negate an inference that a choice of law to govern the contract was intended to apply to the arbitration agreement. But then at 6, additional factors which may, however, negate such an inference and may in some cases imply that the arbitration agreement was intended to be governed by the law of the seat are A, any provision of the law of the seat which indicates that where an arbitration is subject to that law, the arbitration will also be treated as governed by that country's law. Now, that is not our case here. Or B, the existence of a serious risk that, if governed by the same law as the main contract, the arbitration agreement would be ineffective. Either factor may be reinforced by circumstances indicating that the seat was deliberately chosen as a neutral forum for the arbitration. So that those are important points. That factor B, my lord.
Are you planting on factor B?
Well, my lord, I'm saying that factor B is certainly something which we do rely upon. Why? Because here the law of the main contract is effectively an addition of laws. So one can't say, reading the contract as a whole, that it is only English law which applies to the contract. It is English law plus unidroit. And that was the choice of the parties. But the guidance here, if it were to apply in a convention case and arguendo, is clear that in that circumstance, because English law requires the arbitration agreement or a choice of law for the arbitration agreement to be a national law, that there wasn't a clear choice. And if there were no clear choice, thinking again of the words clear in the Rome 1 regulation, and that standard must be the right standard in order to, at least the right standard in order to arrive at an express choice, but we put it higher. We say that an express choice must be expressed in unequivocal language. And so because there's no hierarchy or precedence, we say that the choice of English law under Article 15 is equivalent with the also, in inverted commas, choice of unidroit at 14.3 second sentence. And so we say that the choice here is clearly not effective in terms of English law and unidroit applying to the arbitration agreement because they can't. And then it says, subparagraph 6, that last sentence, either factor may be reinforced by circumstances indicating that the seat was deliberately chosen as a neutral form of the arbitration. My Lord Sales.
Yes, I just wanted to ask, why doesn't the rule of English law that requires that there be one choice of national law to govern an arbitration agreement not underline the force of the express choice in Article 15, that that national law was to be English law? Your argument seems to be, because English law generally says you have to choose one law to govern the arbitration agreement, that knocks out Article 15, because you say it's, if you look at the substantive terms of the contract, there are aspects of unidroit which are to be operated as well. But why doesn't that background feature of English law operate against your argument and emphasize that the parties did indeed intend, as they said in Article 15, that it is English law which is the sole national law which should apply in relation to the contract?
My lord, my answer to that is, well, it's because the express choice of the parties in the contract included a deliberate and express choice not to seat their arbitration in London. And when one takes that together with the fact that they chose to apply English law and unidroit, there was a deliberate choice of a neutral forum. And one might even say there was a deliberate choice of a neutral amalgamation of laws, or potentially neutralizing amalgamation of laws, because they chose English law plus unidroit to apply to their contract. And what I say, my lord, also is that there is nothing in the language of the contract which seeks to give greater force to English law to have precedence over unidroit, nor indeed which, if there were a London seat here, of course, none of us would be here. But there's not a London seat, and the parties didn't choose a London seat. They expressly chose to put their arbitration in a neutral third country seat, and they expressly chose to amalgamate laws, and they chose in doing so to add unidroit to English law. So we say that it can't be something which strengthens the application of English law as the dominant law, as it were, of the two laws chosen, because that wasn't the language the parties chose. They said that the arbitrators, which is the word they use, but I say it means anyone resolving disputes as a result of the contextual reading of that sentence, or the whole of the four sentences of Article 14.3 in conjunction with Article 14.7. We say that that must mean that the arbitrators would be anyone called upon to resolve disputes. And the language was that those called upon should also apply the unidroit principles, as well as all other provisions of the contract, which include Article 15, but also include, of course, Article 2 and the expressly added provision concerning good faith and fair dealing, which, as I've said, echoes strongly unidroit and unidroit Article or Principle 1.7.
But if you go for that wide interpretation of the second sentence of Article 14.3, presumably a much simpler way to express that would be to word Article 15, saying this contract is governed by English law and unidroit, if it affects not only the arbitrators but everyone else who is involved in the enforcement of the rights under the contract.
My lord, that might have been a slightly more ideal way of forming this unideal world of the FTA in terms of the language which the parties chose to express in their contract. But the reality is, as I've said, that where English law will give or take notice of, for example, the freedom of the parties, if they specify that there's supposed to be a form of contractual hierarchy or superiority or order of precedence of clauses, as one often sees, for example, in major construction contracts, where one might have particular conditions and general conditions, etc., and very specific hierarchy provisions. One doesn't have those in this case, and so there is no. I seek to make no point about the fact that Article 2 is the second article written, or Article 14.3 is Article 14.3, whereas Article 15 is Article 15, and therefore lower down the order of hierarchy of the contract, there's no point to be made there, obviously. But equally, there's no point to be made against the fact that the language used by the parties also apply, compared with governed by, is no different and is non-hierarchical, even if that choice creates difficulties. And the problem, of course, is that if one is dealing with the contract, as this court must, and as the Arbitral Tribunal has, and as the Paris Court of Appeal has, one has to deal with those infelicities. But in response to your question about a harmonious interpretation, my lord, the harmonious interpretation, if one were arguendo to follow the ENCA guidance at paragraph 170, 1 to 9, in this case, because we say that we would fall within the category B additional factor at paragraph 170, subparagraph 6, the harmonious choice is shown to us by the guidance given at subparagraphs 7 through 9 of paragraph 170 in ENCA, because 7 continues, where there is no express choice of law to govern the contract, a clause providing for arbitration in a particular place will not by itself justify an inference that the contract or arbitration agreement is intended to be governed by the law of that place. But then one comes to, in the absence of any choice of law to govern the arbitration agreement is governed by the law with which it is most closely connected. And it follows, the sentence continues, where the parties have chosen a seat of arbitration, this will generally be the law of the seat, even if this differs from the law applicable to the parties' substantive contractual obligations.
I can show you, I've read ENCA 7 to 9, and I'm familiar with its terms, but I don't think that answers the point about harmony within the contract itself, because you say there is no express hierarchy or precedent clause, quite so, but your approach does involve reading the second sentence of Article 14 as if Article 15 didn't exist. And you have to read Article 14, as you've told us, in the light of the agreement as a whole. And that agreement includes Article 15, which you say is distinctly infelicitous because the parties were never subjecting themselves to subjecting their two contracts to English law.
My lord, I made a point this morning about Article 15 when discussing the express language of Article 15, which was this. It was the fact that apply, the word apply or applicable law, one often sees boilerplate clauses which say the applicable law of this contract shall be X law. Equally, one often sees clauses that say, as in this contract shall be governed by X law.
Yes.
There's no difference, I say, between the words apply or govern in that sense.
I'm accepting that in your submission, but how does that help you?
Well, my lord, it doesn't help me make, from a judicial perspective, of what would have made good sense. It doesn't help me to show what the parties might have done. They could have done better, would be the end of term grade in terms of the drafting of this contract, because they chose to use the word also. They chose to amalgamate two sets of one national law and an international set of legal principles. And if govern equals apply and you accept that submission, then there is no difference whatsoever between the language of Article 15 and the language of Article 14.3 second sentence. And the question at the end of the day is also partly a question of approach and whether one has a purposive approach in some way, shape or form to reading the contract from a judicial or arbitral perspective, or whether one is simply trying to give effect to what the contract expressly says in its language. And the express language infelicitous or unfortunate though it may be, is the express language of the contract, to which we have to ensure effect is given. And that express language of the contract leads one to the fact that there is an importance when parties designate a neutral third country forum as a seat of arbitration. That importance is clearly spelled out at paragraph 170, 6 to 9 in Anchor. My Lord Hamden.
Just going back to Anchor para 176B, which you say you rely upon, that applies where there's a serious risk that if the arbitration agreement is governed by the same law as the main contract, the arbitration agreement will be ineffective. Now, whether it's the main contract law is English law plus, neither lead to the conclusion that the arbitration agreement is ineffective, do they? If so, how?
My Lord, we say that it leads to the conclusion that the arbitration is ineffective because it's not a solution which is permitted by English law. Perhaps we should, shall I take you to the passage in Russell upon which we...
No, but why is the arbitration agreement thereby rendered ineffective?
Because the choice of law is not effective in respect of the arbitration agreement. And so it's not a form of arbitration agreement governed by a national law which English law recognizes. And that's in order to fall within, well, that falls within, we say, the additional factor at 6B under paragraph 170. But also, and in any event, here we have a situation which perhaps wasn't one of the additional factors which the panel considered in Anchor when formulating and restating the common law test in respect of English seat arbitrations. And that is the fact that there has been a dual choice of law, but also a very clear choice by the parties to seek their arbitration elsewhere. And it is important, we say, that they clearly chose not to seek their arbitration in London. And that is a factor which reinforces, because it was a deliberate choice under... Yes, my Lord Legate.
You placed a lot of weight, Mr. Chair, on a sentence in Russell on arbitration on page 1954, saying that the common law requires that the law applicable to an arbitration agreement must be the law of a country. You didn't, I think, read the next sentence, which says the analysis may be different if the court is considering the law applicable to the arbitration agreement in the context of an application to enforce the award. And it then goes on to refer to section 1032B of the Arbitration Act, which is exactly our situation.
Yes, but
do you have an alternative submission that if it is English law plus in this case, the Court of Appeal was wrong to find that Unidroit didn't help you as a matter of who was a party to the contract?
my Lord, I do, and I will come on to, if I may, discuss the convention test if I can move to the next section of my submissions.
Yes, Mr. Shea, I think we have given you a large number of questions. We will let you develop your submissions. Thank you.
I'm grateful. My Lord, is there a transcriber break at all during the afternoon session, or are we simply continuing?
Would you like a short adjournment?
My Lord, it might help simply because I've dealt with quite a lot of submissions in answers, I hope, answers to questions. And what I need to do is perhaps in terms of time, because we have a chess clock running, and I believe in terms of the total 7 hours of hearing time allowed, each of us have 3.5 hours with me to use mine as I please. And my intention, of course, is to seek to finish my submissions today in respect of all three issues, but it may be that I eat up part of what would have been reply time and move and have to move even into briefly into tomorrow morning. And
well, you will have an allocation of time tomorrow morning because you didn't start till 12:10. So by 4 o'clock, you will have only spent 3 hours, less than 3 hours of your submission. You'll have at least 10 minutes in the tomorrow morning in the allocated time for your principal submission. And as you say, you reserve the right to use some of your reply time in your principal submission.
Yes.
But if you think it will speed things up to give you a 5-minute adjournment, then given the disruption that you've been caused today, I think it would be only courteous for me to do so. So do you want to adjourn for 5 minutes?
My lord, I'd be very grateful. Yes.
Yes. Well, all you need to do is put your microphone to mute and stop your video, and we will all do the same and resume in 5 minutes. The court will.
I'm grateful, my lord.
Mr. Chair, I think we are ready to resume. Thank you.
My lord, I'm grateful. I now want to turn to my submissions concerning the convention test and the way in which it may be somewhat different to the common law test. The starting point, of course, in any convention case is that there's a prima facie valid foreign arbitration award, which here the appellant seeks to have recognised and enforced by the English courts, made through an application for recognition and enforcement. Now, the respondent has entered a section 103(2)(b) challenge, and also 103(2)(a) challenge in this respect. Now, this court recognised, of course, in ENCA that the New York Convention, to which the UK became a party in 1975, and which more than 160 states have now signed, and I quote here from paragraph 126 of the judgment ENCA, is the single most important pillar on which the edifice of international arbitration rests, and perhaps the most effective instance of international legislation in the entire history of commercial law. That's at bundle page 1758 in ENCA. And of course, as stated at paragraph 126 also in ENCA, the essential aim of the convention was to establish a single uniform set of international legal standards for the recognition and enforcement of arbitration agreements and awards. Now, there is, of course, consistent authority culminating in the recent decision of this court in ENCA at paragraphs 126 to 30 concerning the pro-enforcement policy of the New York Convention. The fact that it prescribes its own conflict of laws test, and in that respect I think of paragraphs 128 of ENCA at page 1759A to B in the bundle, and also paragraph 291 at pages 1812B to F in the bundle per Lord Sales. Now, this court has also confirmed, of course, that Article 51A prescribes its own conflict of laws test, and that exercise covers both questions of validity and scope of the arbitration agreement, and that was paragraph 1 through 8 of ENCA at page 1762, in which the majority of this court said, thus, it is logical to apply the law identified by the conflict rules prescribed by Article 51A of the New York Convention and Section 103(2)(b) of the 1996 Act to questions about the scope or interpretation of the arbitration agreement, as well as disputes about its validity. My lords, I say it's hard, therefore, to overstate the importance of this case to the future application of the Convention in practice among the more than 160 contracting states, in circumstances where the decision of this court on the application of the Article 51A test to determine the law applicable to an arbitration agreement will likely influence or persuade enforcing courts in nearly a third of those countries. We think the number is, to be precise, 48, but that's without taking into account any of, for example, the financial centre courts, such as those which have sprung up in certain jurisdictions, such as the UAE, at the ADGM, the DIFC, and of course those international financial centre courts also effectively apply either English or English-derived law. We have also referred to Article 3 of the Convention and the suggestion that this court should take some notice of the fact that the Paris Court of Appeal, which was the supervisory jurisdiction chosen by the parties who seated their arbitration in Paris, has confirmed the validity of the foreign award in question here, and that was by its decision of 23rd June 2020 at page 561 of the bundle. And that, of course, is the only court as the supervisory jurisdiction, the court of the seat, which has the power as curial court invested with supervisory jurisdiction to consider whether to annul the award, and it upheld the award. Now, it was the respondent herein which chose to submit itself to the jurisdiction of the Paris Court of Appeal by making its annulment application, and it's bound, we say, by the decision of the Paris Court of Appeal to uphold that decision. Now, that is a matter to be taken into account by this court, although this court is not bound in any strict sense by the Paris Court of Appeal decision. And in fact, the reality here is that the respondent submitted to the jurisdiction of the arbitral tribunal, argued fully the merits of the case and lost, and then took the further step of submitting to the jurisdiction of the Paris Court of Appeal by making an annulment application. The respondent's written case proceeds upon the premise that the common law test to determine the law applicable to an arbitration agreement is no different to the convention test to determine the law applicable to an arbitration agreement. And we said indeed, paragraph 22, I beg your pardon, paragraph 22 in its written case, the respondent sought to argue that Article 5.1a does not contain or prescribe a conflict of laws test. In support of that contention, the respondent mistakenly quoted a passage from Professor Vandenberg concerning what was called a halfway conflict rule. But that was actually taken from a passage where Professor Vandenberg was discussing another part of Article 5.1a of the Convention relating to party under some incapacity. That's at, that passage is at page 1825 in the bundle, where Professor Vandenberg said, it is questioned whether the phrase under the law applicable to them would supersede these conflict rules of the latter countries and would oblige them to conceive a personal law for the sole purpose of Article 5.1a of the Convention. It submitted that this is unnecessary. The phrase in Article 5.1a gives a halfway conflict rule, since what is to be considered as the personal law is still to be determined by the conflict rules of the forum. In view of that fact, in view of the fact that the phrase did not give a complete conflict rule and hence does not guarantee a uniform method for determining the applicable law, it may be deemed to be permitted by analogy to substitute for the incomplete conflict rule of Article 5.1a the complete conflict rules of the forum in those countries where the personal law rule is unknown. I place emphasis on the words personal law rule because it's clear that that wording concerns, in fact, the question of incapacity, or whether a party was under some incapacity, which is the first limb, in fact, of Article 5.1a under the Convention.
Could you give me the page number again, please? I'm so sorry.
Yes, my lord, it's page 1825.
Thank you.
Now, my lords, we say that the respondent's approach is not the correct approach to the application of the Convention, because as noted by my Lord Sales at paragraph 291 in ENCA, that's bundle page 1812, the default rule under the Convention test is much less flexible and less nuanced than is the common law rule. At paragraph 289, and this is bundle page 1811, my Lord Sales said, and this is halfway down the paragraph, as I've sought to show, the policy of the common law as reflected in the default rule at stage 3 is to align that rule with the likely result the parties would have wished to achieve to produce reasonable coherence across their whole contractual relationship. Application of Article 5.1a would defeat that policy because it would produce a radical divergence between the effect of Stage 1, Stage 2 and Stage 3 of the common law rule. Another way of putting this is to say that the points made by Lord Hamden and Lord Leggett at paragraph 53 of their judgment do not drop out of the analysis for the purposes of the common law test at Stage 3, but continue to have validity and force at that stage as well. By contrast, when one is applying Article 5.1a, those points do drop out of the picture and have no force, precisely because the New York Convention legislates for a rule which excludes them from being relevant. At paragraph 291, the second sentence, the judgment continues, Article 5.1a sets out a default rule within the scheme of the Convention, which is different from the default rule under the common law, and which, if applied, would undermine the validation principle when it is applied by the common law as an aspect of Stage 3. See paragraph 285 above. Because the common law might, just a parenthesis, solve a problem with the validation principle where the Convention would remain inflexible if, for example, an award were found to be not valid under the law of the country where the award was made. I go to slightly further down the paragraph at 291 in the judgment of Enker. Article 5.1a thus sets out what can fairly be described as a very simple and inflexible default rule for the purposes of the Convention regime, which is different from the more flexible and nuanced common law default rule of closest and most real connection, and should not be taken to displace that rule. Within the Convention regime, the rationale for the choice of a simple test is not difficult to understand. It is a clear rule by reference to which it is reasonably easy to judge whether the actions of states party to the Convention comply with it or not. Now, what we say, my lords, is that the policy consideration which informs the English common law test is clearly the presumption that parties would want one system of law to govern their entire contractual relationship, as stated by Lord Sales at paragraph 289 in Enker, but also, of course, pursuant to the list of considerations of principle at paragraph 53 per my Lords Hamden and Leggett concerning certainty, coherence, avoiding uncertainties and complexities, avoiding artificiality, and ensuring coherence of the whole. Now, the general rule restated in Enker for the common law test is that clearly if there's a choice of main contract governing law, then the presumption is that that law should apply to the arbitration agreement, unless, as I've said already, there are additional factors which we say we have here, which point towards the law of the seat of arbitration. But the New York Convention test is somewhat different. It's informed, obviously, by slightly different policy considerations and proceeds with a different purpose and objective. The simple purpose and objective, of course, is within the title of the treaty itself. It's a treaty to try and ensure that there is recognition and enforcement of arbitral awards by enforcing courts in contracting states. The object is a uniform approach between enforcing courts, and the Convention expects the treaty reciprocity from contracting states, which I've already discussed earlier in relation to Article 3. The appellant submits that the opinion expressed above by Lord Sales in his judgment concerning the simple and inflexible test under the Convention is correctly stated. The policy of the Convention test is clearly that the law of the country where the award was made, and so almost invariably the law of the seat, will apply to any Article 5.1a challenges as to validity and scope of an arbitration agreement if there's no clear, no unequivocal express choice. And we say also if there's no clear implied choice, because the words "or failing in any indication thereof" must reasonably be taken to expect that there would be, if either an unequivocal indication, or if not, then at least a clear indication in order for there to be any inference of an implied choice. My Lord Legate.
Can you just help me with this, Mr. Chair? You took us earlier today to the passage in Inca where we said that applying the common law test, we should interpret the contract in accordance with English law principles of interpretation to see what choice, if any, the parties have made. When we apply the New York Convention test as enacted in Section 103, and we're deciding what law the parties have subjected the arbitration agreement to, do we there also apply English principles of interpretation in deciding whether the parties have subjected the law, the arbitration agreement to any particular law, or do we apply some other set of interpretive principles, and if so, what are they?
My Lord, one applies the normal English rules, the ordinary English rules of contractual interpretation to which I've made reference during today, and arguably, and this is the matter for this panel to decide, of course, one might apply the guidance which was provided by you, my Lord, and by Lord Hamlin in the majority judgment, paragraph 170 in ENCA, because that is the state of the English law when considering the common law test. The question is whether there is whether this court, in seeking to give effect to its treaty obligations, should reconsider whether there should be any difference to the guidance in respect of approach to contract interpretation, because one's going to apply the normal English rules to try and achieve a business common sense interpretation of a contract and treat the arbitration agreement as a contract and look at the whole contract within which it is contained. But then ENCA provides a very particular lens through which one looks, and guidance, which is from the policy perspective of the English common law wanting to ensure that there's certainty. And so the guidance which this court has developed is to favour a choice of the main contract governing law as being the general rule, but which may be displaced if there is an absence of choice, or if ineffectiveness potentially of an arbitration agreement, or if the law of the seat, for example, if it were the case, as it is with Sweden or Scotland, that the law of France said that it is a matter of French law, that French law shall apply as the law applicable to an arbitration agreement if the seat is in France, then of course we would fall within factor or additional factor A within paragraph 170, subparagraph 6 of your judgment in the ENCA case.
Sorry, can I just ask one more question, David? It's quite important to know. In paragraph 129 of ENCA, Lord Hamlin and I expressed the view, undoubtedly obiter, I think, in that case, that of the two views about what Article 5.1a means, the correct view was that it encompasses an implied as well as an express. Are you asking us to reconsider that in this case, or are you accepting it for the purposes of this appeal?
My Lord, I accept that entirely. As I've said a little earlier before the short break, we say is that the test begins with the law to which the parties have subjected their agreement, which is the express language of subjection, and therefore the express choice part of the convention rule. And that the words "or failing any indication thereon" are the words upon which one can hang the fact that there is also a potentially an implied choice which can have been made and can be given effect to by an enforcing court. But if there be no implied choice and if there be no express choice, then one is left with the default rule, which defaults to the law of the country where the award was made. Does that assist me?
Yes, it does. Thank you.
So, my lords, what we say the Convention expects by prescribing its own specific and uniform conflict of laws test is that acting with treaty reciprocity as expected by Article 3, contracting states, or the enforcing courts rather, contracting states, should apply an internationalist lens and focus rather on an international perspective and interpretation than upon their own national law rules where those might be inconsistent, if they were inconsistent, with the Convention. And this calls to mind, of course, paragraph 111 in our written case, which was at page 181 of the bundle, where we cited Lord Justice Aikins in the Berezovsky case, where he was specifically considering the 1996 Act. And he said, it seems to me that the correct approach for the English court, when a stay is resisted on the grounds of a non-English law arbitration agreement being null and void, is to take the issue in two stages. First, the court must examine and decide on whatever standard of proof may be necessary, see below, the rules of the applicable law of the arbitration agreement, which are said on the facts to lead to the arbitration clause being impugned. Secondly, the court must then decide the effect of that applicable law by reference to the facts and the English law concepts of null and void and inoperative, those being the words of the relevant English statute. Of course, in considering those concepts, the English courts must have in mind that the phrases are taken from an international convention, so they should not be interpreted in an Anglo-centric way, but in a broad international sense. And so the obligation, we say, of contracting states is to ensure that in considering how they apply the Article 518 test, that they ensure that they keep step with their reciprocity obligation under Article 3, first sentence of the New York Convention, page 1295, which says each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon under the conditions laid down in the following articles, being the articles of the Convention, of course. So there's an expectation that enforcing courts will apply the test according to the letter and policy of the Convention. And in that regard, I refer to paragraph 156 of our written case, which was at page 193, where we said, however, the manner in which the Court of Appeal dealt with this case has set English law on a potentially retrograde course in dealing with convention cases, which may increase the risk of divergent interpretations between the English courts and the courts of other contracting states, if undue weight is given to the intention of the parties imputed from the perspective of the national law of the particular enforcing court. So we do say that my Lord Sales was correct to point out that in a convention case and applying that test, the question of whether the particular policy considerations listed at 53 in ENCA drop out of the picture does arise. But of course, having considered the decision in ENCA, we also are conscious of the fact that there may be different views within the court on the degree of difference which exists between, on the one hand, the 518A test and of course its proper application, and on the other hand, the common law test to determine the law applicable to an arbitration agreement. And so, as I've already discussed, I think, in answer to questions, we submit that arguendo, and if it be found by this court that the guidance at paragraph 170, subparagraphs 1 to 9 in ENCA, which was given in respect of the common law test, if that guidance is to be applied in addition to the ordinary English rules of contract interpretation in this case, then we still say that either we fall within additional factor B at paragraph 170, subparagraph 6, or that indeed there are additional factors which should be considered here, because we are looking at an international contract between non-English international parties where those parties could not agree on one law to apply to their contract, where they specifically chose to amalgamate and add laws. applicable to their contract. English law, but in their words, also uni droit. And where they also chose a neutral third country forum as the seat of arbitration, which was an inferred, or which comported with it an implied choice, obviously, of French law as the supervisory, as the law of the supervisory jurisdiction of the court of the seat. And we say that, of course, under the convention, one should give effect to the clear expressis verbis language which was used by the parties to the FDA. I've made the point already, and won't return to it again in respect of the requirement of English law concerning national law. I will seek to provide tomorrow the reference to which the next sentence to which my Lord Legate referred in Russell at 2119 relates, because I think that from recollection, it relates to saying that the convention test may proceed from a different perspective than the common law test, but in a way which is positive potentially for the appellant's case. Now, as we also explained in our written case at paragraph 29, and that's page 158, and also paragraphs 127 to 133 at bundle 184 to 185, the validation principle mandates the application of the law which upholds the validity of the arbitration agreement, the validity of which falls within the scope of the curial jurisdiction of the supervisory courts of the seat, because they are the final competent judicial authority if an unhappy respondent and then award debtor wishes to apply to annul the arbitration award. That's where that award debtor must go, to the courts of the seat. That, we say, does not have the effect, of course, of removing from the purview of enforcing courts their prerogatives of review, but it does uphold a contracting state's general treaty obligation of reciprocity, the appellant submits, where if the supervisory courts have already upheld the validity of the arbitration award on an annulment application made post-award. Article 3, properly read and construed, given the intention and purpose of the convention, does expect a contracting state enforcing court to at least take some judicial notice of a decision of the court of the seat, at least where the court is in another contracting state. Now, as the panel will be aware, of course, among the more than 160 convention contracting states number many of the most well-known and often used seats within the world of international commercial arbitration. What we say here is that in the present case, the validation principle cannot lead to the application of English law only to the arbitration agreement, as that would create a distinction which is artificial as between English law and uni droit, and which the parties on the express language of their contract did not agree, did not consent to. It's totally contrary to the express wording that they chose to use, because those considering the contract, this court in this instance, should also apply the uni droit principles, and that's per the second sentence of Article 14.3. On the other hand, we say that the application of French law to the arbitration agreement, being, of course, the law of the seat chosen by the parties, deliberately so, cannot be taken to contradict in any way the strict wording of the FDA, because it's one of the provisions of the FDA. Article 14.5 is just as much provision and just as equivalent a provision in terms of force, because there's no hierarchy or order of precedence clause, as Article 15 is. There was a clear choice of parish seat by the parties. They chose, well, if French law be applied to the arbitration agreement, then there's no question of conflicting laws which are potentially applicable to that arbitration agreement. And as I've stated earlier today, and I think this is a reasonable fact to be inferred, the parties envisaged, because of the language of Article 14.7, even if it was incorrect in law, because they hoped for automatic enforcement, they hoped that there would be no review of any merits by any competent court of any jurisdiction, they thought and believed that they were contracting to finally resolve disputes, and that in the happy world of if the award debtor didn't pay the award, then they'd be able to automatically enforce. Well, that clearly was their mistake. They were wrong about that, but that's what they believed, and that was why they clearly instructed the arbitrators only, because they didn't expect any other authority or court, it appears, to be deciding any dispute related to the contract. Thirdly, in respect of French law as the applicable law of the arbitration agreement, it does help to bring harmony or a harmonious interpretation to the whole, precisely because, as I've said, it doesn't in any way contradict the strict wording of the FTA. There wouldn't be any conflicting laws applicable to the arbitration agreement. And further, in terms of validity and binding validity, as with the application of preclusion under UNIDROIT, applying French law, as we've clearly seen the arbitral tribunal do, and then the Court of the Seat, the Paris Court of Appeal, KFG is considered to have become a party to the arbitration agreement as a result of its substantial performance of the FTA. So in terms of a few brief concluding comments, if I may, my lords, concerning issue 1. I have already referred you, my lords, to page 1969 of the bundle and Article 3 of 3.1 of the Rome 1 regulation. That was, of course, a regulation which your lordships took into consideration when considering the international perspective in the case of ENCA. And I've taken you to the fact that that article clearly requires that a choice which is made must be made expressly or clearly demonstrated. And that is what I use or deploy to support the submission which we have made clearly in our written case, that any express choice must be a choice which is unequivocal, or at the very least, if that's too high a bar, clear. Where the language clearly states that there is an express choice which is dual, however unfortunate it may be, it's an express choice. And if that is an express choice which is made of two laws, then we say, because there's no sharp division between the question of express choice and implied choice, and in the face of equivocation within the language of a contract without orders of precedence or hierarchy clauses, and where apply is equivalent to govern in linguistic terms, we say that there can't be priority or hierarchical superiority given to either English law or UNIDROIT. And so for that reason, we say that there is no clearly demonstrated express choice, no clearly demonstrated implied choice, but if there is any clear indication, anything enough to be any indication thereon for the purposes of the convention test, then it must be the choice of seat, which comports with it the choice of French law as the law of the seat and the French courts as the supervisory jurisdiction of the arbitration. And that sits in perfect harmony, we say, with the choice of the parties to apply dual laws, English law plus UNIDROIT, as the governing laws or applicable laws of their contract, but to choose not to seat any arbitration in London, to choose to seat it in Paris, a third country, and a neutral forum, and therefore submit the arbitration to the supervisory jurisdiction of French law and the French courts. My lords, that concludes what I have to say in respect of issue 1. I'm conscious that I think we're only 2 minutes away from the bell. Is that correct, my Lord Hod? Because
we have 3 minutes to go.
well, my lords, I don't propose to embark if your lordships will permit on issue 2 now, because I think it will be disjointed if I only have 2 or 3 minutes to begin.
As you wish. You will have, as I said, 10 minutes of the principal time initially allocated to you, and then you also had some reply time that you can choose to eat into if you need to.
My lord, I certainly I can indicate already that I will need to eat into my reply time. I may use as much as half of it.
Yes.
In order to deal in 40 minutes or so with issues 2 and 3 tomorrow.
I see. Well, that's fine. I mean, an hour reply time is quite a generous allocation, so I don't think that will cause you embarrassment.
I'm grateful, my lord.
Well, in that event, although we're not yet at 4 o'clock, the court will now adjourn, and we'll resume tomorrow morning. Thank you.